This is Scott Horton. I've just opened up the room for today's webinar. People are just logging in. We're scheduled to start in a couple of minutes. I'll give everyone a chance to join us. Julie, do you want to say hi just to do a mic check?
Good afternoon, everyone. Can you hear me, Scott? No? Scott,
Yeah, I
can you
hear.
hear me? Oh, okay.
I do. Yep. You're good. So again, people are rolling on in. We're just going to give everybody a couple more minutes to get logged in. You should be able to see the cover slide for the presentation, preparing the post-pandemic workplace. You should have access to a chat window where you could type in questions. That's what we'll use for question and answer. When we get started officially in a minute, I'll go over all the particulars, but as you're getting in, I want to help you get settled in and oriented. Should be able to hear me and Julie as we talk and see the slide and have access to the chat. If you have all that, then you should be in good shape. Again, welcome as people are joining. We'll get started in just a minute or two. Appreciate all of you taking the time to join us on this interesting and ever-developing topic. We'd all rather not be here because of the circumstances, but we hope that we will be able to provide some good information to you. Again, we'll get started. We're at about the scheduled start time. I just want to give people a few more minutes, or probably just maybe 2 more minutes to get logged in. Thanks to all of you typing hello into the chat, so we know that that's working well for most people anyway. Hopefully no one's having serious technical difficulties. If you're having any trouble, you can always try logging in again. Sometimes if you close out other applications on your computer or device, that will help. But for the most part, it looks like everyone is able to see the presentation, hear me, and type as they want to in the chat. All right, I'm going to go about 30 more seconds, and then I'm going to formally start the presentation. That should have given everyone a chance to sign in. All right, I'm going to go ahead and just say hello and make the introduction of myself and Julie, and then we will get started. So the last few people who are able to log in right now will be able to get in before we start the substance of the presentation. We are speaking today on preparing for the post-pandemic workplace, just getting started when it's over, a term that, as I'll discuss further in a minute, we use somewhat loosely under these circumstances. I'm Scott Horton, founder and attorney with Horton Law PLLC in Orchard Park, New York, just outside of the Buffalo area. We practice labor and employment law primarily and represent employers throughout New York State. Some of those employers have operations elsewhere, and we know that some of you are joining us from outside of New York. We'll address some of those issues in a moment as well. Joining me today is Julie Bastian, who's also with Horton Law. Julie, you want to say hello?
Yes, good afternoon, everybody. Hopefully we'll address any issues that your companies are facing during the reopening or in anticipation of reopening.
Okay, so again, you have the slide with the cover of the presentation in front of you. You have access to the chat window and you can hear us. Then you are in good shape. We will provide a copy of the slides after the presentation. I will post a link at the end that you can click to access them immediately. At that point, you will also receive an email tomorrow with the link to the slides if you prefer to get them that way. You can ask questions throughout, just type them into the chat room and we will answer them most likely at the end. But if we happen to see a question that we can easily answer where we are in the presentation, we may choose to do that. We are going to aim, as we normally do, for about an hour at least for the the formal portion of the presentation, but for the question and answers, and we anticipate there will be a number of them, we will stay on as long as it takes to answer those questions, at least within reason. So don't get concerned if your question is not answered immediately. We will go back and try to get to it and give you an opportunity to type it in again if for some reason you feel that we haven't addressed it. So with that, I'm going to go ahead and get started. I just remind you as you're typing in questions that we are lawyers. This presentation is for general informational purposes. If you ask a question that's very specific to your workplace, we won't be able to provide quote unquote attorney legal advice with an attorney-client privilege because there's other people present. If you need privileged legal advice, make sure you contact your attorney and get that from them. And even if you are our client, the same applies and we need to speak to you offline. But we're happy to help with general information to the extent we can. First, the big picture. The new normal is a term that is being thrown about pretty regularly right now based on everything we're seeing and synthesizing overall. I'm looking at the new normal as being what happens after we get to the stage of widespread vaccination for the novel coronavirus and the COVID-19 disease. Before we get to that point, we're really, in my view, in a state of chaotic transition. There's very little consistency at this point from day to day, from state to state, from location within states to other states. For various reasons that I'll allude to momentarily. And your particular organization or workplace's reality depends on numerous factors, many of which are beyond your control. So let's take a look at some of those factors to sort of synthesize what I'm saying by way of background. Location matters a lot. Our audience is, I think, all in the United States. Your companies may have operations elsewhere, or you may be elsewhere with operations in the United States. But even within the United States, there's 50 states, and all of them have a governor who is doing something different, which ranges from following federal guidelines exactly to hardly following federal guidelines at all, to allowing local government leaders discretion to manage their cities or towns differently, to dictating how things are going to go on a statewide basis. There's also regional coalitions of governors and states trying to work together to manage their approach to both the virus itself and reopening businesses, schools, etc. We are, again, in New York State. We will talk a little bit specifically about the New York structure, but most of the presentation will be sufficiently applicable regardless of where you are. There's just no way we could give a 50 state specific presentation. We couldn't even give a New York specific presentation in the time we have. And even if we tried, governors are passing new executive orders, issuing new directives, et cetera, on a daily basis. The science is changing on a daily basis. What we think is the reality of the virus is changing on a daily basis. So we're going to do the best we can. I'm not guaranteeing a lot of answers to all of your questions. We're hoping we at least help you ask some of the right questions and understand the types of challenges that probably lie ahead. Your industry matters quite a bit. Obviously, there are some industries that are essential everywhere and are operational: police, fire, hospitals, medical providers are pretty well operational across the board. There are other businesses like restaurants that typically are being allowed to operate in a different capacity than they usually do. Namely, they have to do takeout or delivery only types of services rather than sit down dining. Other industries are in manufacturing, and where it might depend on what you actually make as to whether you're operating, whether you have customers at the moment, whether the government is compelling you to operate even in some cases. So, that's a big factor. The size of your company matters. In some senses, it's nice to be big because you might have more resources, but being big and having more resources could mean having more employees, having more customers, having more fixed cost and overhead, which leaves you little flexibility. On the other hand, being relatively small might make you somewhat more nimble, but means you don't have the embedded in-house resources, whether that be cash and capital or human capital, or just the ability to do multiple things in ways that you haven't done them before, which is almost certainly going to be necessary of just about everyone trying to operate in a business or workplace going forward for the foreseeable future, at least. Employees are another big factor, not only based on the number that you have, but also their views and preferences and thoughts and flexibility. There are some employees who are going to be very reluctant to return to the workplace. There are some employees who are on unemployment who are going to be inclined to stay there. There are other employees that are eager to get back to work. And again, depending on how large your workforce is, a few employees refusing to work even though there's work available can have a big impact on your business, especially if they're critical employees. Of course, if you're larger, you might be able to afford a few people not wanting to come to work. On the other hand, you need more employees to operate your business. So if a larger percentage of your employees are reluctant to work, that can create issues. I've already mentioned the resources. Again, this is multifaceted and it ties into all these other factors. And then among other possible factors, I put management on this slide. Different respects, it's always a factor in how successful a business or operation is going to be, the level of its management capabilities and skill. But what I'm really focused on here is the fact that most, virtually all businesses were set up to operate in a world that looks different than what our world looks like right now. While the management structure may have been perfectly well suited for the way business was 3 months ago, adjusting to ever evolving regulations, restrictions, expectations, requirements, consumer preferences, employee demands, etc., put new pressures on the business and ultimately then on management to respond to it. And for better or worse, some businesses are going to be better equipped to adjust to those circumstances than others. I'm going to spend a whole lot of time on these guidelines, but as a backdrop, I just want to reference the White House guidelines from about 2 weeks ago, where the White House, through the president, announced a recommended 3-phase approach to reopening states. They identified data-driven conditions that should be satisfied before the state proceed to opening. And then when they do proceed to opening, suggest a 3-phase approach to doing so. Gave some guidelines, again, for what states should do to meet the challenges ahead, and identified responsibilities both of individuals and employers that is businesses during all of the various phases. Just quickly for background, many of you have already familiarized yourself with this, but the federal sort of prerequisites for reopening states look at the symptoms that are being demonstrated, the number of cases that are being documented, and what is going on at the hospitals. Traditionally looking at 14-day periods at these various criteria, and overall just looking to see roughly a 14-day downward trajectory at least of symptoms reported, cases, and the availability of hospital bed capacity, personnel to treat cases that may come up. Again, this is all discretionary. It's not a requirement from the federal government. So I'm not going to, go into too much detail, but just as far as operating businesses goes, I wanted to show the highlights of the 3 phases that the federal government has outlined. The first phase is starting to reopen, where schools are still closed, childcare and similar youth activities are still closed. There's no or very limited visitation to nursing homes. Places that people go are starting to reopen under phase 1. Restaurants, movie theaters, sporting venues, places of worship with strict physical distancing protocols. The extent to which these places can open effectively with the quote unquote strict physical distancing protocols remains to be seen, but that is kind of what's envisioned in phase 1. Some hospitals can resume elective surgeries on an outpatient basis. Gyms can be open with strict physical distancing and sanitation protocols. And for whatever reason, the White House makes a point to point out that bars have to remain closed. So they are at least distinguishing bars from restaurants in this guide. The phase 2 operations, it's kind of highlighted on this slide in green where these different items change. So now schools under the federal guidelines can reopen. Virtually all of the states have already closed schools through the rest of the 2019-2020 school year. So how relevant that is in the short term remains to be seen. New York notably still has not made that call. Many of the handful of other states that still have schools open are in dramatically different situations as far as number of cases than New York. But New York is expected to announce, or Governor Cuomo is expected to announce by the end of this week what his plan is for schools this year. The restaurants now move to moderate physical distancing under phase 2. Elective surgeries are available both on outpatient and inpatient basis, and now bars can reopen with diminished standing room occupancy, according to these federal guidelines. Phase 3 is when we really get back to what we previously considered normal, or as close to it as the guidelines suggest. You can resume visiting nursing homes, senior living facilities, and hospitals. Restaurants now only have to maintain limited physical distancing protocols. Gyms just have to go back to their standard sanitation protocols, and bars open with increased standing room occupancy. I assume that means increased from phase 2, not necessarily increased from where they were originally before all of this took place. So again, these are recommendations. There's no order compelling states to follow it, and many states have already started adopting approaches that are not entirely consistent with the federal guidelines. So far, most states, the governor has retained their authority at the state level to determine how the state will start to reopen. Some states have already started to reopen. In some states, the governor is allowing local officials to have a greater role in the process where other states are just, the governor's office is telling everyone across the state what is going to happen statewide and prohibiting local restrictions from superseding the state level requirement. The federal recommendations on all of this do say that states should have a preparedness plan and be able to provide adequate testing and screening, personal protective equipment, and medical equipment if COVID-19 cases, especially ones involving hospitalization, begin to rise. So there is a built-in understanding that by opening up the economy, that we are going to risk cases becoming more prevalent again, at which point the idea is you better have the ability to address that, and you shouldn't be reopening until you have the ability to address that. And implicit also is the idea that if things start to get out of hand again, then you would need to close back down to a greater or lesser extent. Just real quick, I'm going to hand it over to Julie. In New York, Governor Cuomo has identified a two-phase approach. There's a lot more phases in the big picture, but his two-phase approach to reopening is looking at a phase one where some limited construction and manufacturing can reopen on a regional basis. This would focus on businesses within these industries with a low risk. So ones where physical, so to speak, social distancing is possible and, PPE is available, can be used. The earliest this is going to happen now is May 15th when the current pause order in the state expires. Phase two will occur at least 2 weeks later, apparently, according to this approach, where certain businesses will then probably gradually be able to reopen based on some matrix that evaluates what's more or less essential, what's more or less risky, and the importance to the economy of the business being reopened. And then this phase two will involve a plan of reopening based on various factors, presumably over time. So we don't yet know the details on that phase two, but that is the idea that we are following in New York, and many other states have plans at various levels of detail and intricacy out there. The one thing to keep in mind as we go forward is most of these plans, certainly New York's plan, is going to envision the possibility, if not the likelihood, that wherever we get on a reopening, we may see future shutdowns if the virus starts to proliferate, or perhaps when we get back into the flu season or the winter months next year where COVID-19 may start to spread again more rapidly, again, depending on whether there is a vaccine yet in place. So with all that kind of background and general idea of what we're all dealing with, I want to turn it over to Julie to talk about some of the specific legal issues that we can already identify are likely to be factors. And I will pick back up from her a little bit later on.
All right, thank you very much, Scott. So the first thing we're going to do is address some of the legal issues that will come up as businesses begin to prepare for reopening and then also upon reopening. First one is your remote workforce, whether or not you have existing people working remote or whether or not you plan to continue to have that occur. Second one is workplace safety, health and safety, and we'll address that in further detail over the next slides. Employee medical testing, overtime exemptions. Currently, if you have overtime exemptions, and whether or not employers have possibly lost those exemptions based on actions they took during the pandemic. USERA compliance, so it's individuals on military leave and their reemployment when they return. And then productivity versus liability, that employers need to weigh the options under both.
You trying to move the slide, Julie?
Yeah. Can I not do it?
It's under the slide. It's really hard to see.
Oh, I got it. All right. Sorry about that, guys. Okay, so remote workforce. Many companies, well, first of all, companies may have started out with part or all of their workforce working from remote places, whether most likely a home. But after some of the governors issued stay-at-home orders, employers were faced with the decision of whether or not they would have staff continue to work from home, whether or not they would allow additional positions and depending on their job duties, have them work from home in order to stay in business. So the question is, what do you do with this workforce moving forward? Also, alternatives that can be considered as they start to reopen. Whether or not can we continue to allow these employees to work from home without disruption to the business once the businesses start to reopen? Can your company do rotating office schedules? I know a lot of companies are utilizing this option right now, so they can alternate days and shifts for their employees so that half of their workforce is in on Monday, Wednesday, Friday, the other half is in on Tuesday, Thursday. However, that structure would work for the company. Also, alternating shifts. Maybe your company only had a traditional 9-to-5 shift before, but if we alternate shifts and create additional shifts for employees to work on, you can spread out the workforce so everybody's not there all in the office at the exact same time. So of course, that's to the extent that type of structure would work with your business. The biggest thing is the changes to the physical workspace. Even when we do return back to work, it's likely that all companies are going to need to maximize their social distancing between employees. And while there was some changes for a long time, people have been going to a more open workforce. So for those that didn't change, maybe they've got the upper hand here. But for those that have close workspaces, employees are interacting with each other without that safe social distancing in place, then they're going to need to consider whether or not there can be changes to the physical workspace within the office to maximize social distancing. So to the extent you do have employees that have to return, is there any way to restructure the desk or utilize parts of the office that weren't being utilized before in order to maximize that social distancing? And then, of course, you have individual employee accommodation requests. So this is more specifically around individuals that have underlying health conditions, but it can be anyone. So those individuals that fall into the high risk categories for contracting the virus, it's very possible that those employees will request an accommodation be made so that they can work from home without coming into the office because of their higher risk. So those are all things that employers will need to consider because those topics will come up. With the telecommuting workforce right now, companies will need to decide what they're going to do to address employee requests to continue to telework. So the one thing we need to look at is the proof of previous success or productivity. So for those individuals that were allowed to telecommute after the stay-at-home orders were put in place, how has it been? Did they actually show that they can be productive? And are guidelines are meetings being attended? Are they meeting their deadlines? Or is there a reduced productivity with that workforce? And can those issues be addressed individually, or is it something that is just not working? It's not just the workforce is not conducive to a telemuting policy or to having workers telecommute. The other thing is childcare needs. With schools and daycares closed, it's very difficult sometimes for individuals to come into the office or to work from home. I think both things have to be considered. Can they continue to successfully work from home with the children in the office? Or the other thing is, if you're going back to having employees physically come to the workplace, they're going to have to address those childcare needs. Hopefully that the reopening of business will go hand in hand with schools and daycares, but it's very likely that it may not. So I think the company has to decide how they're going to handle those issues that come up with their employees. Of course, everyone has concerns with the health and safety of employees when they return to the office. So I think the idea was that the company needs to have a plan for addressing those concerns. How are you what steps is the company taking to ensure the health and safety of their workers or to prevent the spread of the virus? So I think having that plan in place and being able to communicate that to the employees is something that's really important during this time. And then, of course, can you safely return to the office? If you can't, and there are questions, obviously the employee is going to be bringing those up. Then accommodation requests for employees that fall in those high-risk categories or with disabilities. I think you're still going to get those questions that come up, and the company has to decide how they're going to deal with those requests. Are they in positions that can work from home or continue to work from home once your business is up and running again? And, I think those have to be handled on a case-by-case basis to go through that reasonable accommodation process. So for addressing the workplace health and safety, I think employers need to be aware of the following guidelines issued by these different agencies, not only ones that have been passed or posted previously, but these continue to change on a day-to-day basis. So you want to make sure that you have someone that is staying on top of this and making sure that they're complying with any guidelines issued. So the CDC has issued interim guidance for businesses and employers to plan and respond to the coronavirus. I think it's important for companies to review those and make sure that they're implementing any recommendations listed under the guidelines and address all the concerns that they go over in the guidelines. OSHA guidelines, obviously some of their previous guidelines have been updated for this pandemic. So how should employees respond? The documents right now is called the Guidance on Preparing Workplaces for COVID-19. And I think as we start to reopen, there may be some additional guidance that's out there, especially for companies that are returning to business. And I think as we have concerns that companies are returning too early, and if they are, what things can they do to create a safer workplace for those employees that do return? The EEOC guidelines, EEOC has issued the Pandemic Preparedness in the Workplace and ADA. That's really geared more towards how to handle testing and screening, and then making sure that those practices aren't being applied in a discriminatory manner, and then reasonable request from employees for an accommodation. So just making sure that what your requirements are under the guidelines. Some practices that they've always shied away from, they're actually suggesting that companies implement, if they implement screening process, how do you do that, and how do you make sure to avoid claims? So that's why those guidelines are important. And then, of course, any mandate issued by the federal, state, or local government. At least in New York, we're seeing that the governor's frequently issuing executive orders, and I think that's happening in other states as well. You want to make sure that someone is staying up to date on that within the office, and so that you're not doing anything that conflicts with one of those executive orders. Okay. Some consideration that employees or employers must review and determine how they're going to respond when it comes to health and safety. Obviously, we need to make sure that we're implementing those OSHA guidelines and rules. And if they're not already in place, then how are we going to modify the workplace or the policies and procedures so that we're complying with those OSHA rules? Companies need to implement infectious disease controls within the office. And if they were already doing that, that's great. If they're not, then they need to come up with a way to implement those controls that are recommended so that the spread of the disease is reduced as much as possible. Adopt a workplace preparedness policy. Again, some companies might have already had this, but there may be some tweaking needed to the policy given the pandemic that we're currently in. If not, the recommendation is that employers adopt a workplace preparedness policy and address all the different components for bringing people back and ensuring, or at least trying to reduce the spread of the virus and how to handle those individuals that test positive or that display some symptoms of COVID-19. One of the biggest recommendations is to appoint a company representative. Now, this could be a single person or a group of individuals to be the person that communicates to the staff and management on everything, COVID-19, so that you have control over what's being communicated to employees, and there's some type of centralization over that. And I have another slide that addresses that as well. And then training. I think companies need to determine what kind of training what additional training is needed, and that touches all aspects of the reopening. And I'll go into detail in that in a different slide. So for compliance with OSHA, the company needs to decide whether or not they're going to implement screening policies, whether it be, testing individuals for active COVID-19 or antibody testing, temperature checking, looking for symptoms upon arrival to work. So I think the company needs to decide individually how they're going to handle the screening process, and if they're going to implement some type of screening policies, how do they apply that across the board? Personal protection equipment. For the most part, we're talking about masks, gloves when needed, but it can certainly be other type of PPE that employees will need given the type of industry that you're in or the position. But you may need to be issuing those to your employees, maybe even customers that come in to the workplace when needed, subcontractors, whatever it may be. And these are, in some places they're mandated, in others they're highly recommended. So you want to make sure that you have control over that PPE and decide whether or not you're going to allow employees to bring in their own, or if you're going to supply all of that within the office. Adopting procedures for cleaning and disinfecting the workplace is very important. Hopefully everybody had some type of procedure before, but obviously with a pandemic like this, where the spread of the disease is so easy, I think employers have to look at creating other types of procedures for cleaning and disinfecting, not only in general, but during the workday as well. And that might require the assistance of employees, but I think coming up with a plan or recommendation for employees before the reopening is recommended. Social distancing. So how is your company going to deal with social distancing within the workplace? Can it be done? Do we need to look at alternative work weeks or alternative schedules like a 4-10 or a 980 schedule in order to reduce some of that exposure in the workplace, or, moving shifts around to reduce the number of employees that are in the office at the same time? One recommendation would be to continue allowing individuals to work from home. Whether or not you can continue that at the beginning when the business starts to reopen, it's obviously encouraged to the extent possible. The guidelines that are issued by OSHA, if you haven't seen them yet, they address companies having an infectious disease preparedness and response plan, implementing basic infection prevention measures. One of the most important things is developing policies and procedures for the prompt identification and isolation of sick people. So when someone comes in, you do your screening and you've identified somebody who's symptomatic or they disclose being positive. Obviously, you need to, as a company, know how you're going to handle that before faced with the first case of it. If the person's symptomatic, are you going to send them home? For how long? Are you going to require documentation for them to come back? I think all of those things need to be thought out beforehand so that you're ready to go when the offices reopen. Are you considering any type of flexible arrangements in order to protect those employees in the workplace? Have you implemented workplace controls, engineering controls, administrative controls, and safe work practices, and the use of PPE? I think one of the recommendations from OSHA is that everybody go through their workforce and determine which category of exposure employees are facing to COVID-19 based on their work location, their job duties, and your industry. Is it very high, medium, and low? And then you can certainly make decisions based on the risk level. And that will be used as well in the whole reopening phases that the governor, at least in New York, is contemplating. So they want to know, if you did return to work, what is the risk level of employees' exposure to the virus or the spread of the virus within your workplace, and just adopting, overall safe work practices, and having PPE, and then how they're going to deal with individuals that either work out of state or out of country, or that are required to travel as part of their job duties. I think it's important to know how the business is going to deal with that. Having a united front and discussing that beforehand will be very helpful. So for infectious disease controls, again, what PPE is required and how are you going to provide it, and training on the PPE, the physical workspaces, addressing that, and also communicating that to employees once they come back and the physical workspace has been changed. The number of COVID-19 cases, how are you going to, once you identify them, how is that communicated to your workforce, and what do you do with them? Same with symptomatic employees. And again, cleaning and disinfecting procedures. Also, the one I haven't discussed yet is, I hope this goes without saying, but obviously we want to make sure that we're encouraging hand washing and the use of sanitizer where possible. You'd hope employees are already doing this, but to the extent that they're not, just maybe you want to implement some kind of reminders or something like that. I know other companies have gone to even scheduling washing hands and hand sanitizers. And then, of course, making sure that those items are available to your employees when needed. So screenings. The decision to screen your workforce is, I think, going to be left up to the employer, but it's certainly recommended. By screenings, we're talking about a lot of times they're doing temperature screenings when they arrive to work, symptom inquiries. So having a questionnaire that's being given to each employee when they arrive at the workplace. Have you been exposed to it? Do you have any symptoms? Do you have any family or friends that you've been in contact with that have tested positive? And then even some employers are going to implement COVID testing. So and there's two types of testing. There's testing if the person has an active case of the virus, and then also antibody testing. The testing is allowed as long as certain conditions are met, and understanding how your company is going to deal with that and implement any practices and procedures around it is something that you want to deal with. The positive cases, I think, focusing on what are going to be the procedures for those positive cases? How do you communicate to your workforce? How long are you going to have them, either working from home or out of work? And, what's going to be required for the return of that employee? I think those are important things for employers to know ahead of time. Then confidentiality. We all know about confidentiality in the workplace, especially when it comes to medical documents. But I think it's a good reminder, the screening results that the employer gets for all those employees, they're considered medical information. So we want to make sure that they're not being, passed along to various people within the workplace. You're keeping them confidential in a separate medical file. Same with the questionnaire results, and their positive test cases. All of that information needs to be kept in a confidential medical file, not just laying on somebody's desk somewhere where it could be exposed to others. And then proper training for staff. So for those individuals that will conduct the screening and symptom inquiries or COVID testing, making sure that those people are properly trained on how to do the screenings and the symptom checks, making sure they understand what the company's policies are in regards to those screenings and tests, and then understand that information should be treated confidential, because this is going to be a first for many of these people, especially if they're being done by it's not a third party that's handling it, or it's maybe your secretary that's being put in charge of doing it. We just want to make sure that the people that are doing it know how to administer the test and what to do with them, and then training on PPE. So if we're going to be using the masks and the gloves, when to be used, how to properly use them. Just don't take for granted that it's everyone knows what they're doing. So I think being aware of that is something that employers need to do. So I think most of this we talked about, except for the workplaces that will be screening upon entry to the building. So something to think about is whether or not you have multiple entry and exit points within your office, and how are you going to deal with that? So if you're going to decide that you're going to screen all employees when they arrive to work, which it should be done consistently to avoid claims of discrimination, you want to see how you're going to make sure that that you're hitting all the employees when they're entering the office if you have multiple entry points. Now, you might close down those other entry points, or have somebody at each entry point to deal with the screening and testing. But you want to make sure that people don't have the ability to avoid it altogether by going to a different entrance or exit. And then, once you have a positive case or somebody shows up that's symptomatic, a consistent policy on how to handle them to avoid claims of discrimination. I think we talked about this earlier, the company representative. So again, it could be one person or it could be multiple people that are designated as representatives. But those are the individuals that should be communicating with staff regarding anything to do with the virus. What are the current company policies? What are we supposed to do? How do I decide if I'm working remote or I've been given a new shift, or if there's going to be a need once the office reopens to then go back to working from home because there's an increase in cases. I think getting the message from a consistent person or a group of people is ideal. But what we would try to avoid is, false information being distributed among the companies and the employees, especially because it's just going to create panic and fear among employees. Also, the process for reporting and communicating positive cases in your workforce, those should be the individuals that are handling that, so that again they can be trained properly and they're not violating anybody's confidentiality. Reporting OSHA cases, it doesn't necessarily have to be the company representative, but they should definitely be working with the individual who's typically in charge of handling the reporting of OSHA cases, so that that information is accurate. And it's only going to include those individuals where the employer reasonably believes that the person contracted the virus at work. So just because they have a positive on their test doesn't mean necessarily that it's a reportable OSHA incident. It just means that the employer needs to then look into whether or not it's reasonably possible that that individual contacted at work based on their interactions with other positive cases or things like that. And then, of course, you want to make sure that somebody within the company is staying abreast of all new laws and guidelines. And that's, again, from federal government, state government, CDC, OSHA, and EEOC. Because these are changing so frequently, it's really important that somebody in the company is staying on top of these items and that those items are being implemented and then communicated to other employees. So it could be this company representative, or it could be others within the company that need to report to the company representative so it can be communicated to employees. Having a streamlined process is really what's needed. For training purposes, I think we went over the personal protective equipment, making sure that you properly train employees on the use of that. Workplace safety policies and procedures, especially those that have been modified as a result of the pandemic. So you want to make sure that those are communicated to the employees and the employees are trained on it. Same with infectious disease controls. One thing that you might want to reinforce among your, HR or managers is how to handle those reasonable accommodation requests. We want to make sure that we're handling them properly and not exposing the company to any claims of discrimination or retaliation, or that they're not retaliating against their employees because of a request for a reasonable accommodation. Same with USERA. For those individuals that qualify, and USERA is the uniform. I just want to make sure I'm saying it correctly. Hold on. It's the Uniform Services Employment and Reemployment Rights Act. Scott will go over this in more detail, but it's for individuals that are in covered areas that have certain, if they're providing services for the military and certain groups within that that have been they've been activated by the government, and they have to request a leave of absence from work. And there are certain qualifications for each of those things. But if they have rights under USERA, and then when they come back from leave, they have a right to request reemployment. And so you want to make sure that it didn't come up a lot in the day-to-day affairs of many companies. So educating managers and your HR staff, making sure that they understand what those rules are, what the employee's rights are under USERA, and then what to do and how to handle those requests when they come in, again, to avoid any type of claim. So shifting gears a little bit, I want to talk about overtime exemptions. So individuals that were, prior to the pandemic, they were classified as overtime exempt, whether it be hourly or weekly salary. And if those individuals have a change in their compensation structure during the stay-in orders, and then whether or not those individuals have risked, basically, are those employees that experience the changes in their compensation or duties as a result of the pandemic, can the employer still treat those individuals as overtime exempt, or did they lose the exemption by making those changes? So again, a lot of people went to a remote workforce, or for those that were in the office, they had to cut down on hours or compensation for employees, which also included exempt employees. It could have been, permanent layoffs, temporary layoffs, reduction in hours, or compensation across the board. And whether or not the employer chose to participate in an unemployment shared work program. So throughout some of those changes, you want to determine whether or not when they return to a full workforce, can I continue to treat those people as exempt salaried employees, or did I I lose that exemption. So some salaried exempt employees were changed to a non-exempt hourly employee, and others were just, they received a reduction in that salary as a result of what was going on. Sometimes just because they needed to reduce compensation across the board, and other times because the standard work week for those individuals were significantly reduced, and so the compensation was reduced to coincide with the type of work or amount of work they were doing. So for somebody who was an exempt salary person that was temporarily changed to a non-exempt hourly person, and now when the businesses are reopening, they want to change that person back to an exempt salary, some things to consider when trying to determine if you have lost the exemption or you continue to utilize the exemption is whether or not that person was properly compensated for overtime hours when they were moved to hourly. If they don't qualify and meet the duties and compensation test under one of the exemptions, then they have to be paid overtime. So did the company do that correctly? And was the change made in an effort to avoid paying overtime? I don't think that's the case for most employers, but you want to make sure that it doesn't appear based on the facts and circumstances like that's what the employer was trying to do. For those individuals that were exempt salary before and the employer felt the need to reduce the salary during this temporary period of time, did they jeopardize losing the exemption? If for those employees or employers, you want to make sure these items were followed during that temporary period of time, that the salary met the minimum threshold under the overtime exemption under state and federal law. Any new salary, this is, can I continue to treat them as exempt, or can I change the weekly salary again now that they're coming back to work and likely have more hours? What is the employer's ability to change that again? By changing the salary amount, does that jeopardize the exemption? If there's going to be a new salary, then that salary has to be applied prospectively, and the employee must be given advance notice. So it can't be based on, okay, I'm going to pay you, $500 a week, assuming that you're working a 20-hour schedule. But if you move to a 40-hour schedule, it can't be kind of fluctuating each week. It has to be a base salary that is consistently applied. You can certainly change that salary prospectively, but the employee has to be notified of that change, and it can't be for previous hours worked, so previous work weeks. And then again, one of the things to consider is was the change made in order to avoid paying overtime wages, or is there an appearance of that? You want to make sure that you have a documented notes that say what was done and why it was done. Then for every overtime exemption, there's the compensation and the duties test that must be met. So if the duties were changed temporarily for an individual that was previously classified as overtime exempt, let's make sure that those new duties, at least the primary duties that have been modified, do they all fall under the exempt duties that would need to be met by the employee to utilize the exemption. A lot of times there is an increase in non-exempt duties, but it doesn't necessarily mean that the exemption is destroyed. It just means that, for the primary duties, that has to be all those primary duties should be exempt under state and federal law, and that the non-exempt duties don't make up the majority of the work that they're doing on a regular basis. So, as I said, yeah, you can change the job duties throughout the employment, whether it be during that temporary period or moving forward. You just have to make sure that with the new job duties, you're reviewing to make sure they still qualify under the exemptions. And I think now this is where Scott's going to pick up.
Yep. Thanks, Julie. So we're going to just touch on a couple more topics and then move to questions. A lot of questions have come in. If you have them, keep typing them in. Remember, you will get the slides at the end or by follow-up email tomorrow. But I don't want to spend too much time on USERRA. Julie mentioned it already, but it is a topic that will affect some businesses as a result of this coronavirus situation. It's the federal law that allows employees to take military leave from employment. In other words, if they are called to active duty in the military, then they have the right, if they follow the right procedures, to get their jobs back when they're done with their military service. The reason that's important here is that roughly to this point, say 30,000 members of the Air and Army National Guards have been called to duty in support of the COVID-19 coronavirus response efforts. While you may have one or two of those in your organization, you might not. So, this only applies to people who are in that situation. But for those, there's two different paths, because people called to National Guard service under state control, which is typically what happens, may or may not receive federal funding based on nuances in the process that we're not going to get into. But as it happened, the majority, but not that many, more than half of the 30,000 that have been called to the National Guard are subject to USERRA protections, where a lesser number are not currently protected by USERRA. So if they happen to be in a position and have been called under orders that give them the USERRA protections, they will have certain reinstatement rights. If they have not, their reinstatement rights, if any, would be based on applicable state laws. So, this is what USERRA generally covers: the uniformed services, any type of military activity, active, inactive duty, reserve work. And, there's some of that has happened as well, but the bulk of the instances arising out of the coronavirus pandemic relate to the National Guard service. If USERRA does apply, there should have been notice as soon as possible of the need for these people to go to active National Guard duty. And then after that duty is finished, the employees can request reemployment. How long they have to make that request from when their service ends depends on how long they were on National Guard duty, and they will need to provide appropriate documentation. There's some particular nuances to USERRA, which is the main reason I want to bring it up, because it's relatively infrequently relied on, but maybe more so now. The main thing I want to point out is if the employee makes the proper request to return to work and shows the right documentation, not only do they have the right to return to work, but they have the right to return to work subject to what's called the escalator principle. And this is, they have the right to return to work to the position they would have obtained but for the time they spent on National Guard duty. Hopefully, for the most part, the National Guard duty is short enough for most employees these days that they wouldn't have necessarily automatically, especially given economic conditions, received a promotion or something like that. But theoretically, if it lasts long enough to make the argument that they should have been promoted for whatever reason, or especially say someone else was promoted to a position that they might have been promoted to, there is this unique provision under USERRA that would require you to, or a company to promote them to that position, including providing any training that would have been necessary to get them to that level. So that's a very complicated issue that can arise if you have people in this situation. So we want to let you know about that. There are state laws, as I said. New York, for example, has protections on reinstatement of military National Guard men serving where they're not subject to USERRA, and you would need to figure out, again, which law you're providing, because the USERRA provides that escalator principle, for example. The state law doesn't. Under New York state law, public employees and officials of government entities have right to be paid for some of their leave, where private employees don't. They just have the right to be reinstated. So there are those nuances. Before we get into the questions, I just want to kind of wrap up with some general discussion of liability risks, because we're anticipating really two major considerations. One, any given business organization is subject to what the government allows. And a lot of the things that Julie was talking about with screening, testing, etc., we're still not sure whether that's going to be a requirement of reopening in some cases. It's just going to be something you can choose to do as an organization, whether employees are going to be able to say yes or no. A lot of unanswered questions. Again, it's going to vary based on where you are in the state, what industry you're in, and other factors. But there's the second category of issue here as to whether, even if you're not required to do something, you choose to do it for business reasons, including avoiding liability. As an employer, the organization's liability would most likely fall into categories such as OSHA claims, workers' comp claims, wage and hour claims related to payment of wages, overtime issues, and that sort of thing. Discrimination claims, failure to accommodate employees with disabilities, and possibly personal injury claims. The personal injury claims for employees are likely to be covered by workers' compensation. However, there are some potential theories of liability that workers' compensation would not cover. And we also note here that, for any given organization, their liability is not potentially just to their employees, but also to third parties, customers that come into their premises, etc. So from an employer standpoint, the reason you want to take some of the precautions, especially that Julie talked about, is to avoid liability and sickness and injury, not only to your employees, but also to others who come into the workplace. There are some efforts at various levels of government to limit the liability that businesses face under this public health crisis. Early on, there was a declaration issued by the Secretary of Health and Human Services at the federal level, and that included granting some tort liability to entities involved in the creation or distribution of medical countermeasures. So basically limiting the liability of companies that produce medicines, and certain related medical devices that would have helped potentially fight COVID-19, recognizing that we have to take, I hate to put it this way, more risks than we normally would given the public health crisis. There is an argument that this law could extend to some employers in their distribution of PPE or administering of coronavirus testing to employees and provide some protection from tort liability for claims from employees or family members, but that is yet an untested legal theory. There is a not surprising tension between business and worker groups on whether there should be additional liability protections put into place at the federal or state levels. There's legal questions as to the extent to which that could even happen at different levels. And we don't have all the answers to that other than to say we know this is an emerging issue that is going to be discussed quite a bit. The U.S. Chamber of Commerce says we need to get back to business, but we can't get back to business effectively if we have to risk lawsuits We can't bring people into the workplace and have them be productive if we're worried about them getting coronavirus, noting, of course, that people who get coronavirus are not going to be easily identified or distinguished from those who get it at work versus those who picked it up somewhere else in all cases. The president of the AFL-CIO, the primary labor union organization throughout the United States, has conversely demanded that there be further protections for employees, and they're going to oppose the type of protection that business groups want. So we can't predict how that's going to come out, other than to say that it is going to be addressed and may or may not result in new legal parameters that are going to make a difference to many businesses. President Trump, for example, signed an executive order yesterday saying that meat processing plants can remain open. There's some discrepancy between what might be reported, maybe even what he said, and what's actually in the executive order at the moment. It seems most likely all that the executive order says is they can remain open, even if state dictates would otherwise say they can't. And there may or may not be some liability protections for those employers and businesses. But again, that's not clear from the executive order, maybe subject to further guidelines, and they may or may not be valid and will probably be challenged on legal bases. So a lot of uncertainty, not surprisingly. We're going to get the questions in just a minute or two. Like I said, we will stay on to answer all the questions that we can, but the presentation is going to wrap up just with me giving you some sort of long-term predictions that the result of this coronavirus crisis is going to be new legal parameters for business operations, not just in the short term, which is going to be dizzying the amount of regulatory and legal guidance just to get us through the crisis. But in the long run, we're going to see major changes, I think, in different areas. New York, for example, has a new sick leave law that it's already passed to take effect later this year. So additional focus on sick leave, worker protections are going to come in certain places, but in other places and from other angles, there might be new protections for business operations as well. There's going to be increased teleworking in different ways. We've already seen how it can work, which is to say, well, in some cases, not so well in other cases, but for various reasons, we are likely to see more telecommuting going forward than we did in the past. One of those reasons is that the overwhelming majority of schools at every level in the United States are currently engaging in teleeducation, and it's pretty clear that this is going to compel public schools, private schools, K through 12 and at the university level to be more capable of proceeding in that capacity if need be. Once people start going to school from home, there's going to be more reason for people to work from home, as of course we've already seen. So that's going to be a lasting trend, I believe. We're going to see a rebalancing of many industries. This means a lot of different things. One thing it means is that if you're in manufacturing, you might be producing new items. PPE is going to be more popular than other goods for the foreseeable future. A lot of items that used to be manufactured overseas, in Japan in particular, are now likely to see ramp ups in the United States, if nothing else for supply chain reasons. So the whole gamut of businesses are going to feel some impact, and that's going to create new winners and losers. It is likely, from my perspective, that all this is going to reinvigorate union organizing. The labor movement will get a bump, if you will, from this. We've already seen it. Different people, different prominent employers at different locations have employees not happy about working conditions, and that is the type of thing that often prompt people to seek assistance from a third party, in that case, a labor union, to try to help them get better conditions. So will not be at all surprised to see more union organizing activity than we have seen in the recent past. And for that and a bunch of other reasons, it should create a greater emphasis on employee relations among workplaces. There are going to be more options, concerns, fears, etc., than ever before among employees, and to be successful, businesses will need to manage that as effectively as possible, you know, to a greater extent than in the recent past. So with that, I just want to remind everyone, or let you know, that we do have a newsletter where we send out monthly information if you're interested about that. Obviously, this will continue to change. The fastest way to get new information that we have available is through our LinkedIn page. So you can find Horton Law on LinkedIn, where we post regularly, nearly daily these days, with updates. So take advantage of that if you want to get more information. We would appreciate it. We're going to take questions now. In just a minute, I will post the link to the slides if you want to go ahead and download those. Like I said, you will get an email tomorrow that will confirm your attendance for the webinar, and will give you a link to the slides and to a recording of the webinar if you want to watch any part of it again or share it with a friend or colleague. So let me go ahead and post that. Start typing in any more questions that you have, and then we will start answering those.
Scott, so I had a chance to look through some of the questions. Would you like me to get started in answering some of them?
Sure, go ahead. Yeah, I think I just posted the link to the slides, so anyone who wants that should be able to click for that.
Okay. So I think the first question was about whether or not employers can mandate employees to be tested. And I think Scott already addressed this. We're waiting for further guidance on whether or not the government will mandate that employees be screened or tested, and to the extent that they don't, whether or not employers can mandate the screening or testing for COVID-19. I think, unfortunately, there's not a perfect answer on that. I think to the extent that they do require it, that it must be applied consistently across the board to avoid claims of discrimination. And I think it's kind of a wait and see right now. And I think employers are going to be reacting based on what additional guidance comes out. Do you agree with that, Scott?
Yeah, the EEOC has guidance out that says, yes, you can mandate testing as long as it's job related and consistent with business necessity. And at the moment, that's generally true of COVID-19 testing. Again, that's the federal government saying that you should be able to do it without violating basically the ADA, which is the Federal Disability Discrimination Law. I think it's probably true under most state laws that protect from disability discrimination as well, but technically you would have to check your state laws to see whether there's additional layers. But certainly doing it consistently is going to be a key factor and subject to any parameters that the government may put out.
Okay. The next question, or a couple questions that came up, were about HIPAA waivers as they apply to the testing, screening, and communicating of symptoms. So it's important to remember with HIPAA that the law is really intended to protect the disclosure of health information. So when it comes to the employees doing or employers doing the screening and testing, it doesn't actually, the actual consent, the HIPAA consent doesn't apply to whether or not the employer can do the testing or screening. It applies to whether or not they can disclose medical information. So it would really only apply when you're talking about some type of test that was done in the office, and those results need to be communicated to a third party, whether it be CDC or the doctor or whoever it may be. And in that case, yeah, you would need a waiver. But just to conduct the testing or screening, a HIPAA waiver wouldn't be required. Next question is about, so if somebody is symptom free and they can get a doctor's note saying that they're free of the virus, can that be used in place of being subjected to the screening or testing by an employer? And I think the problem with that is the COVID-19 test, so there's two different tests, but the active test really only tells somebody if they at the time of the test they were infected by the virus. But for before and after that date, it doesn't necessarily give you any information on those two things. So the person can contract the virus the next day or even that day later on in the day. So it's great that they have that information, but I don't think it's necessarily going to be helpful to the employer if they're talking about your possible exposure to the individuals at the workplace moving forward. So I think the screenings would still be necessary, again, as long as they're consistently applied. Now, the antibody testing that's a little different. So if you're saying, can I be waived from actually having, if you already had the antibody test done, maybe, but I don't know why you would want to, because it only tells you at that point in time. So yes, it's helpful if you test positive, but if you were negative, that doesn't tell you whether or not between the time the antibody testing took place to the time the employer wants to take it, if you have somehow contracted the virus. So I think the HIPAA, there's also a question about whether they lose their right to HIPAA protections. And I don't necessarily think that applies in this case, because it only applies where there's a disclosure. So if the employee is willing to voluntarily provide the medical documentation to the employer of previous testing or screening, then I guess that's the only way I can see it applying, or the need to disclose results that occurred in the testing or screening that the employer administered.
Yeah, I mean, I would just, clarify, I guess. I mean, there's no way an employer can make an individual take a test, but that's not to say that they can't make taking a test a condition of continued employment. So if any individual employee doesn't want their employer to know the result of a test, that's fine, but it may mean they won't be able to keep the job. But what Julie said's right. I mean, if you want the doctor to provide information to your employer, you need to give them authorization to do that. Again, you don't have to give them that authorization. They can't require you to, and the employer can't require you to. But if you don't give that authorization, then you don't have to. But otherwise, the point you made, Julie, is exactly right. I mean, the value of any test is still questionable for various reasons. One, there's a whole lot of doubt as to what a positive antibody test actually means at this point. And two, it's only, especially with the positive or negative for coronavirus, at the instant that the test was taken. And in most cases, it's still taking longer to get the test result than it would, give you any comfort that you haven't suddenly contracted the test. So if you go to the doctor, you're not getting test results for a couple of days. In most cases, you could have easily picked up the virus in the meantime. But let me comment on something else, because the link I posted to the slides was wrong. I put the right link in the chat, so hopefully you have it there. If there's any more questions on that, I apologize for putting the wrong link in, but you can scroll into the top of the chat and you should have the right link.
Okay. The next few set of questions pertain to schools and college campuses, and particularly with students. The one thing I will tell you is they wanted to know, will students have to be tested or screened, and then whether or not FERPA applies in this scenario. So I do want to tell you that the Department of Education has released guidance, like a FAQs on the applicability of FERPA to COVID-19. And I don't know if I can send that link or how it would be helpful, but basically it's saying that there are exceptions to FERPA, and one of those exceptions are in the instance of an emergency, and COVID-19, based on how it's treated by the government, it's been declared an emergency. So communicating information with regards to the contraction of COVID-19 or information related to a student, I think the FERPA wouldn't apply. But there is detailed Q&A that has been released by the Department of Education. So if you find that helpful, I can certainly forward that along.
Yeah, I mean, as far as whether schools or any other businesses are going to require it, again, it comes down to the two-part question of what does the government require, and if the government wants to require that, I mean, they can certainly find the authority to do it, subject to legal challenges, like we've already seen with other immunizations and stuff like that. But and then whether the schools want to try to require it for various reasons. But there are possible legal challenges to that, so we can't say whether anybody's going to do it. But at this point, nothing would surprise me. So it's possible. I just wanted to get back to a question we had about remote workers and workers' compensation. So my first note is that workers' compensation laws vary from state to state, and obviously I can't address all 50 states, but as a general matter, most states would recognize that if an employee is actually performing work from home, then an injury they suffer in the course of that work would be potentially covered by workers' compensation. The questionable cases come into, I have a home office, I'm sitting in my home office doing my job, and then decide I want a snack, and I walk to my kitchen and slip on the floor in my kitchen and injure myself. Is that a workplace injury or illness? And that's going to depend from state to state and case by case as to what the outcome is going to be. I know Julie said earlier that working from home is encouraged. What she meant was not necessarily that we're encouraging it as much as that's what all these guidelines are encouraging, and that's the way a lot of the directives have come out. So as I said in my conclusion, I think remote working is going to remain at a heightened level, forever, basically, now, for various reasons that will potentially have more impact on the workers' comp system than it ever has before. But ultimately, that's going to be a case-by-case basis in the first instance, including whatever discussions your business has with its carrier as to what your coverage looks like and what impact people working from home is going to have on your premium. The other point to note is, certainly an open question in any given case, whether it's safer or more dangerous to have somebody working from home. People can get injured in the workplace, people can get injured at home if they're doing their job, and that causes the injury. Then, for the most part, workers' comp probably can and should apply. Workers' comp technically designed to protect employers from other remedies with limited damages provisions and that type of thing. As far as the further question of what responsibilities should the employer take to monitor safe remote working conditions, that's a good question. I mean, you have ergonomic concerns in the workplace. Do people have the right desks, chairs, seating arrangements, and whatever? Ideally, you would also make arrangements to make sure that their home workplace is safe and conducive to them doing their jobs. But the extent and what your responsibility is, really comes down to how good of a job do you want to do to try to keep people safe and healthy. There's no absolute requirement. OSHA, which would have potential health and safety requirements, generally does not oversee a home office setting. So people working in their home office usually don't get OSHA oversight. There's more scrutiny if you happen to have employees in manufacturing, for example, from their homes. Theoretically, you could have people take projects home to work on in their garage or home shop or whatever, in which case OSHA would have more applicability and some of their industry regulations could apply in home workplaces.
So the only other point I would make to that is, to the extent possible, I think it's encouraged for employers to have a detailed teleworking policy where issues of injuries and times for rest and meal breaks are will be addressed in there. And to the if possible, which I realize in this situation, it's very well the case that it might not be possible given the widespread of the individuals working from home, but it's recommended that you talk to the employee about their workspace and review the details, or even visit the workspace to go over, any glaring issues with the workspace. But for the most part, if you have a policy and it kind of addresses those issues, it's definitely recommended.
Yeah, and a lot of that is advice and guidance you will get from your workers' comp carrier. I mean, some of them may even go so far as to require you to get a picture of your employee's home office set up, for example. So, again, the more the better, quote unquote, subject to reasonable parameters of what's feasible. We have, let's see, I'm just looking at this question. Are students entitled to tuition refund? I mean, that's, I'm afraid, really beyond what we can talk about in this setting. Um, Employees to quarantine for 14 days if their partner had the virus. Does the 14 days start after the last symptom? Could we also ask this employee to give us a doctor note that she is cleared to work? Hey, there's a lot going on with that question, and it probably depends on more factors and variables than we have there. We'll know we did a presentation last month that included discussion of the new federal paid sick leave, coronavirus paid sick leave law, and the expansion of the federal FMLA to cover certain COVID-19 situations, as well as a new New York law that protects employees on quarantine, and there's other states that have different guidance. But under general disability discrimination principles, for example, an employee whose partner had the virus isn't necessarily disabled, so you're not discriminating against them for having them not work. Now you say, can you ask employees to quarantine? I mean, sure, you can ask people to do anything. You certainly couldn't make an employee quarantine because you couldn't confine them to their home yourself unless you're a government health department or something like that. So really a lot of moving parts to that question, but even assuming you change the facts enough to where the employee themselves had symptoms and you don't want to have them work, then generally the EEOC, for example, is taking the position that because of the risk of direct health and safety in the workplace, you can have those people not work. But you got to keep in mind what the various leave protections are, whether they would have to be paid, how long they get to be off from work, whether they can telework, and whether that affects their leave entitlements and those various other things. I don't see any other questions at this point. If anybody else has any more, let us know. If you have any follow-up questions after the fact, then here's our contact information. You can certainly reach out. Did you see any other questions that we haven't answered, Julie?
I didn't.
Okay. All right, well, we appreciate it. Thanks for staying on. Finished up at about an hour and a half with the questions. So thanks for those of you who hung on with us. Again, you'll get an email tomorrow with your confirmation of attendance and with the link to the slides. Again, sorry about the slight technical issue on that one. But if for any reason you haven't already gotten the slides and you want them right away, just email me and I will get them to you. But the link is in the chat and you will get the link tomorrow along with access to the replay to watch any portion of this again. With that, I think we'll say thanks and sign off.
All right. Thank you very much.